Hello, everyone, and welcome to Module 6. In this particular module, we're going to be talking about contributory negligence. What makes this different is that in the past 5 weeks of this unit, we focused on the negligence of other individuals that caused harm to others. So you might have a defendant who, by his negligent actions, caused a plaintiff to suffer harm or injury. When we talk about the topic on contributory negligence, though, it's different because our focus is on the harm or injury that is suffered by a plaintiff himself as a result of his or her own negligence. In other words, a particular plaintiff suffered harm or injury, and that is a result of negligence to which the plaintiff or the plaintiff himself or herself contributed to. And as I said, when we spoke of negligence in the past few weeks, we talked about harm or injury suffered by a plaintiff as a result of the negligent action or omission of a defendant. So we're going to look at this more. Now, as well, when we talked about negligence in the past 5 weeks, we said that in order to prove the tort of negligence in an action for the tort of negligence, there were at least 3 elements that had to be proven. One, that the defendant owed a duty of care to prevent harm of the kind that was suffered by a plaintiff. Because if there was no duty of care, then an action on the basis of the tort of negligence will not succeed. Now, that is an important point because what we need to remember in relation to the topic on contributory negligence is that a person actually owes no duty of care to take care of himself. So a potential plaintiff can be very negligent, and in his or her own negligence, that person can suffer harm. And in that case, because it's just a plaintiff, it's just the individual suffered harm, there is no liability for tortuous action. So there is no rule which says we shouldn't harm ourselves by our own negligence. We can be very negligent, but for as long as our own actions don't harm another individual, then there is no tort of negligence. Or if by our own actions, even if we end up harming ourselves, if it wasn't as a result of the negligence of another individual, let's say a defendant, and then you contributed in that aspect which led harm to yourself, then in that particular case, there can be what is known as contributory negligence. Now, these things are going to be clearer as we talk about contributory negligence in this particular module. So that's one. So one of the elements that is needed in order to prove the tort of negligence is that the defendant owed a duty of care to prevent harm of the kind suffered by the plaintiff. Secondly, the other aspect is that although it can be established that there is duty of care, there has to be proof that that duty of care has been breached. So that's the second element of an action in the tort of negligence. And thirdly, it must be proven that the breach was in fact a cause of the damage suffered. And as we recall, there are 2 aspects to it. One is the issue of factual causation, and the second one is about the issue of legal causation, or issues about policy, which talks about remoteness and whether or not the actions of a particular defendant could be considered to lead to what is known as a scope of liability on his part. So those are the 3 elements. But another element that is crucial when we talk about the tort of negligence, as we see shortly, is that there's ordinarily a defense that can be raised by a defendant. And that defense is that the plaintiff himself, by his own negligence, contributed to the harm that he or she suffered. So you might have cases where, had it not been for the contributory negligence of the plaintiff, maybe because the plaintiff was intoxicated, or maybe because the plaintiff was not careful enough while he was doing his tasks or duties as an employee, then the plaintiff would not have suffered injury or damage, or the plaintiff would not have suffered the kind of damage that he did. So that's the point about contributory negligence. If it could be established that the plaintiff was also negligent and that negligence contributed to the harm or injury that befell him or her, then that can be raised as a defense in an action of the tort of negligence. So we're going to be looking at that in greater detail in this particular module. So at the end of this module, students should be able to understand the scope and definition of the defense of contributory negligence at both common law and statute, outline the essential factors taken into consideration with the courts in dealing with the defense of contributory negligence, and finally, to identify and apply appropriate defenses in particular fact scenarios. I would also need to highlight the fact that there are actually a lot of defenses that could potentially be raised by a defendant in an action for on the basis of the tort of negligence, such as the voluntary assumption of risk, or the fact that the actions of an individual may be considered to have been illegal. We're not going to be examining those because they're not going to be covered in our unit, nor will they be covered in an assessment. So instead, our focus when we talk about defense will be that aspect of contributory negligence on the part of the plaintiff. Okay, so as an introduction, at common law, when we talk about negligence, we would say that there is negligence if someone fails to do what a reasonable person would do or does what a reasonable person would not do. So that is what we mean by negligence. So if somebody fails to do what a reasonable person is expected to do or does what a reasonable person would not do, and that action or conduct then leads to harm to a plaintiff, then that particular action or omission would then be considered to be negligence under the common law of torts. Now, that particular principle does not apply only to the defendant when by his negligent action or omission that leads to harm to a plaintiff. It actually applies to a plaintiff as well. In other words, as far as the plaintiff is concerned, he must not engage in actions or omissions that are considered negligent, which would then lead to harm or injury to himself or herself. Because if the plaintiff suffers harm or injury as a result of his own negligence, and that particular negligence is coexistent with the negligent actions or omissions of a defendant, then there is scope for the application of contributory negligence. Now, we need to note that that is different from those situations where you have multiple defendants who are being negligent, and by the commonality of their negligent actions, that leads to harm to a plaintiff. In that case, you might say that all of these defendants have contributed to the harm to a plaintiff, but it is not what is considered to be contributory negligence. When we speak of contributory negligence in this particular unit, or under tort law, we're talking of contributory negligence on the part of the plaintiff, and as a result of the contributory negligence, the plaintiff himself suffers harm. It is not a defendant who suffers harm, but the plaintiff. Okay, now, so in essence, when we talk about contributory negligence, it actually signals that the plaintiff failed to take reasonable care for his or her own safety. So in Commissioner of Railways versus Ruprecht, which we talk further in this particular lecture video, the High Court said that contributory negligence differs from negligence because there is no duty of care owed to another person as far as contributory negligence is concerned. Contributory negligence involves conduct which exposes the actor, the plaintiff, to the risk of injury without necessarily exposing others to risk. So it's the contributory negligence of the plaintiff which leads harm to himself. If it leads to harm to another person, to a defendant, then that is simply negligence. That is what we ordinarily would speak of as tortuous action that leads then to an action on the basis of torts. Now, at common law, what was pretty harsh about the concept of contributory negligence was that if the plaintiff contributed or was contributory negligent, and his or her own negligence caused harm to himself or herself, that provided an excuse for the defendant not to bear any loss for the injury to the plaintiff. So in other words, if I as a defendant suffered harm because I was also negligent, even though it could be established that the defendant himself may have been primarily responsible for the negligent action that led to me being harmed, the fact that the plaintiff himself contributed to the harm by his own negligence, that would mean that the plaintiff cannot recover. So in other words, the plaintiff bore the entire loss, which was pretty harsh. In other words, it was all or nothing recovery for the plaintiff. So at common law, if there was contributory negligence on the part of the plaintiff, he couldn't recover. So it was all or nothing, which you have to imagine can be pretty harsh, because even if the defendant were in fact, responsible for certain negligent actions or omissions, if at common law, if the defendant could show that the plaintiff himself or herself was also negligent, then in that case, the plaintiff at common law would not be able to recover. So that was, pretty harsh. And an example of this would be the case of Butterfield versus Forrester, where in this particular case, the plaintiff had been riding a horse at high speed while the plaintiff was drunk, and then he ended up colliding with a pole. And in that case, the court said, the common law court said that two things must concur to support this action: an obstruction in the road by default of the defendant, and no want or ordinary care to avoid it on the part of the plaintiff. But because in this particular case, it was shown that the plaintiff had failed to take ordinary care for his own safety, then his action failed completely. So imagine a situation where you're walking along a footpath and there are obstructions from a construction that was undertaken, for example, by a local council. And the obstructions that the local council had placed could be considered to be dangerous and would likely lead to injury to anyone using that footpath. But let's assume that a plaintiff was also being negligent, in the sense that the plaintiff was probably looking at the mobile phone, not paying attention to the surroundings, and as a result, the plaintiff then stepped on one of those obstructions and injured himself or herself. At common law, that plaintiff, because there was contributory negligence on his part or her part, would have failed in an action for tort. So that was really a problem. And now, in a sense, the harsh effects of this rule was ameliorated by the last opportunity rule, which says that if the plaintiff's own negligence was only a defense if she had the last opportunity of avoiding the accident. So if the defendant had the last opportunity of avoiding the accident, then the defendant was liable in full. So it could be one of those situations where somebody may have crossed a road at high speed, which would be considered to be an intersection would be considered, and in doing so, it can be considered that the action was negligent. Under the last opportunity rule, if another vehicle who was on the right actually saw that there was the speeding car which was violating traffic rules, and this particular car could have had the last opportunity to avoid the accident but did not, then in that case, under the last opportunity rule, the plaintiff would still be unable to recover, because it was actually the plaintiff who had the last opportunity to avoid the accident. And in that case, under both rules, the all or nothing recovery for the plaintiff would apply. Now, but again, in general, the common law rules in relation to contributory negligence and the issue about the last opportunity rule was considered to be a bit harsh. And as a result, the state parliaments decided to intervene. And one of the key legislative developments in relation to the all or nothing rule was that it had to be changed. So instead, the state parliaments decided that there should be a rule on apportionment. So in other words, a way of apportioning blame, or a way of apportioning the apportioning the liability on the basis where both plaintiff and defendant contributed to the harm that was suffered by the plaintiff. And in Queensland, the consequences of the plaintiff's contributory negligence on the plaintiff's claim can be found in the Law Reform Act of 1995, Section 10, as well as the Civil Liability Act of 2003, Queensland, Sections 23 and 24, which we examine in greater detail in a short while. So let's begin by looking at the statutory intervention under the Law Reform Act of 1995. So under Section 10 of that particular statute, apportionment of liability in case of contributory negligence. So if a person, the claimant or the plaintiff, suffers damage partly because of the claimant's own failure to take reasonable care, so in other words, there was contributory negligence, and partly because of the wrong of someone else, then A, claim in relation to the damage is not defeated because of the claimant's contributory negligence. So in that particular section, Section 10(1)(a), the all or nothing rule embodied in common law has been modified. So even if a person, even if a plaintiff or claimant is responsible for contributory negligence, that alone will not defeat his claim for damages. Now, at the same time, under that particular provision, it says that the damages recoverable for the wrong are to be reduced to the extent the court considers just and equitable, having regard to the claimant's share in the responsibility for the damage. So there's now an attempt at apportioning the cost of the damage. So if a claimant contributed to the harm by his own contributory negligence, then his share of the damage will be apportioned to him. So under the scheme, under the particular provisions of the Law Reform Act, contributory negligence is a way in which a reduction in damages may be made based on the plaintiff's share of the responsibility for the damages. So again, what it points out is that the all or nothing rule has been abandoned by statutory intervention. Now, while it is often referred to as a partial defense because it's a partial defense because the liability of the defendant is not completely reduced. So because there is the element of apportionment, actually both the plaintiff or the claimant and the defendant each share in the cost of the harm. So in other words, it is not a complete defense, it's a partial defense. What is important to remember, however, is that under Section 24 of the Civil Liability Act, it actually permits the court to reduce the liability of the defendant if the negligence of the plaintiff could be shown to be 100% responsible for the ultimate harm. So under Section 24 of the Civil Liability Act 2003, Queensland, that particular statute permits a plaintiff's recoverable damages to be reduced by 100%. In other words, practically nothing by reason of the plaintiff's own contributory negligence. So in a sense, it's almost like, the all or nothing rule is still there, but that's not really the case, as I said, because in general, what the courts will simply do is to apportion the damage based on the respective contributory negligence of both the plaintiff and the defendant. But in those situations where it can be shown that it was really the negligent action or omission of the plaintiff that was the cause was substantially the cause of the harm, then it is possible that the recoverable damages would be reduced by 100% or nothing as a result of contributory negligence. So in section 24, it says that in deciding the extent of a reduction in damages by reason of contributory negligence, a court may decide a reduction of 100% if the court considers it just and equitable to do so, with the result that the claim for damages is defeated. Now, when we speak then of the standard of care in relation to contributory negligence under Section 23 of the Civil Liability Act 2003 Queensland, and remember, when we speak of standard of care here, we're not talking of the standard of care by a defendant towards another individual or towards the plaintiff. We're talking of a plaintiff, the one who suffers harm, and the standard of care expected of a claimant or somebody who suffers harm. So we're talking of the standard of care. So under Section 23, the principles that are applicable in deciding whether a person has breached a duty also apply in deciding whether the person who suffered harm has been guilty of contributory negligence in failing to take precautions against the risk of that harm. Okay, now for that purpose, the standard of care required of the person who suffered harm is that of a reasonable person in the position of that person, and the matter is to be decided on the basis of what that person knew or ought reasonably to have known at that time. Now, this is a crucial point because what it essentially means is that when we talk about the standard of care in relation to what we would expect of a plaintiff who suffers harm and as a result of his own contributory negligence, we actually look towards the common law, where we use the reasonable person as the benchmark to determine the level of care, or the standard of care that would be expected. So we can go back to the common law. It's an objective standard. Because remember, it's an objective standard on the basis of what a reasonable person would do in the position of that particular person who suffers harm. So we go back to the common law. And because we speak of the reasonable person using objective standards, it raises the question then of what standard of care would we then expect, for example, if we deal with children? Do we apply an objective standard of a reasonable person? And in other words, if you speak of a reasonable person, are we speaking of somebody who's adult, who's mature, or are we speaking of a modification of the standard of care expected, where the plaintiff who contributed, who contributed to his own harm by his own negligence, would we be adjusting the standard of care that is required? We're going to be looking at that question. We're also going to be exploring the question of, so when we speak of a standard of care on the basis of what we would expect of a reasonable person, what about those instances when you have a plaintiff who has some, intellectual disability? Or what about those instances where the plaintiff may have contributed to the harm by his own negligence, but this was because the person had been affected by intoxication? Would that factor come into play? We're going to be looking at these scenarios in this particular lecture video as well. So, because we said that we actually go back to the common law in looking at the standard of care that we would expect a claimant or a plaintiff who suffers harm by his own contributory negligence, what it essentially means is that to establish the defense, the defendant must then prove that, one, the plaintiff was at fault or negligent. It doesn't have to be that the plaintiff was fully at fault. It only means that the defense has to show that the plaintiff himself or herself was also at fault or was also negligent, and that the fault or negligence of the plaintiff contributed to the injury or loss suffered by the plaintiff. And finally, that the damage was a reasonably foreseeable consequence of the plaintiff's fault or negligence. In other words, the damage was within the risk created. And these are principles, which we've certainly covered in the previous weeks when we talked about the uh, the the elements that have to be shown by a plaintiff in order to prove the liability of the defendant in an action based on the tort of negligence. So we've so far covered, the all or nothing rule under the common law pertaining to contributory negligence. We also said initially that as far as contributory negligence is concerned, this is distinct because it is not so much it is not so much looking at the actions of a defendant that causes harm to another. The focus is on the actions of the plaintiff himself that caused him or herself harm by his or her own negligence. So let's look, and we then said that the harshness of the all or nothing rule under common law was ameliorated and modified as a result of statutory intervention, in particular the Law Reform Act of 1995 of Queensland, as well as the Civil Liability Act of 2003, Queensland, sections 23 and 24. Now, to better understand the principles pertaining to contributory negligence, it'll be nice to look at case law. So let's have a look at some of these cases. So remember, again, just as a reminder, when you speak of contributory negligence, it pertains to a failure by the plaintiff to take reasonable care for her or his own safety. Okay, so it's the focus is on the plaintiff. So in the case of Commissioner of Railways versus Ruprecht, Chief Justice Mason, or Justice Mason at that time, said that contributory negligence involves conduct which exposes the actor to the risk of injury to himself or herself without necessarily exposing others to risk. Now, what kind of standard should be applied? As we initially said, it is an objective standard to be applied when assessing the plaintiff's conduct. So it is not a subjective standard which looks at the peculiar characteristics or idiosyncrasies of a particular plaintiff. The standard has got to be objective. And because, as we know under the common law, if you use a subjective standard, then there is no limit to what kind of standard could be expected, because if it's subjective, if it's peculiar, if it's idiosyncratic to each particular defendant, then there is no end, because there are many ways by which every individual can be different. So instead, what you have is an objective standard based on what a reasonable person would be expected to do. So, for example, in the case of Jocelyn versus Berryman, Wentworth Shire Council versus Berryman, where both parties were drunk, the court said that the test of contributory negligence is an objective one. So what it means is that contributory negligence, like negligence, eliminates the personal equation and is independent of the idiosyncrasies of the particular person whose conduct is in question. So, for example, in the case of Jocelyn versus Berryman, both of these individuals, a man and a woman, had been drunk, and it was initially Berryman who had been driving while drunk. They were both drunk. The woman passenger was also drunk, and then the woman said, "Hey, you're drunk. You shouldn't be driving." And she kind of scolded Berryman, who got angry and said, "Okay, if you think I'm not a good enough driver because I'm drunk, why don't you drive?" And which is what happened. It was then Jocelyn who was driving, but Jocelyn also was herself drunk. And a few meters from where they changed places in terms of what's going to be the driver, what's going to be the passenger, then they then crashed into an area which was under the control of Wentworth Shire Council. And in this particular case, of course, the liability of Wentworth Shire Council because of that dangerous intersection, but that dangerous curve was shown because the council ought to have taken reasonable precautions to avoid harm. But at the same time, there was an attempt to establish contributory negligence on the part of both parties because they were both drunk. And it couldn't be argued that Jocelyn, in other words, couldn't claim that she couldn't be negligent because she was drunk. So in other words, she was arguing that because she was drunk, her ability to think properly was obviously therefore affected and impaired. And shouldn't the test of negligence or reasonable care be measured in relation to somebody who is drunk? Because if I am drunk, then I can't think well. So that was the argument. But the court said it is an objective standard. It is not because it's an objective standard, and we use it on the basis of a hypothetical reasonable person. You don't think of it on the basis of somebody who is intoxicated, but on the basis of somebody who is sober. So if somebody were sober, what would that sober person or non-intoxicated person do under the circumstances? That was the relevant legal issue. And of course, a sober, non-intoxicated person would have decided not to be a passenger of a vehicle driven by somebody who's drunk. And so therefore, it was established that both individuals, Jocelyn and Berryman, were contributory negligent under the circumstances, and therefore there was a reduction in their claim of damages. So under the statutes, the standard of care required of a person who suffered harm, as I said, is that of the reasonable person in their position. And the matter is determined on the basis of what the person knew or ought to have known at that time. As we said, it's an objective test, and it's grounded on the issue of reasonableness. So in the case of Consolidated Broken Hill Limited versus Edwards, individuals should care for themselves as much as they expect others to care for them. People should take responsibility for their own lives and safety. We're going to be talking about this particular case in a short while. But note that under common law, it is, and we know this, it's pretty obvious, right? People should take responsibility for their own lives and safety. And that goes back to the issue of autonomy. You can't really expect, others to take care of your responsibility. You can't say, it's your responsibility to ensure that I am safe. No, you yourself, whether you're a driver or a motorist or in whatever capacity, also have an obligation to make sure that you yourself are safe. Now, in the case of Carey versus Lake Macquarie City Council, a cyclist ran into a bollard placed in the middle of a path that was found by the court to have little practical usefulness. So in this particular case, this was a cyclist that had been, cycling often. This was early in the morning, and but in this case, the cyclist, was not as careful as would have been expected. It was kind of traveling fast, and but it was in an area where there was a bollard that was in the path that was put up by the Lake Macquarie City Council. And the court found that there was little practical usefulness for that bollard having been placed. So there was negligence clearly on the Lake Macquarie City Council. But the defendant sought to show that there was contributory negligence on the part of Carey, because Carey was not, did not take reasonable care to take care of himself under the circumstances. And the court said that a reasonable person in the appellant's position would have been, in other words, the plaintiff, would have been alert to the risk of encountering a bollard in the dark as it took the lower pathway and should have traveled extremely slowly. And so the culpability of the appellant and the respondent were equal, such that they should bear equal liability for the damage. So yes, there was negligence on the part of the Lake Macquarie City Council, and therefore, the council's defendant was liable for the tort of negligence, but so was Carey, the cyclist, because the cyclist had failed to take reasonable care for his own safety. And there are also many other case examples where a reduction was made for contributory negligence. For example, the case of Rod versus Hall. A hotel guest slipped in the bathroom and fell. So in this particular case, the hotel guest had been staying in that particular hotel room for quite some time and was therefore familiar with the bathroom, whether it was slippery, whether there were problems with the tiles and so on. And she wasn't careful, and she slipped and fell. And the court found the hotel to be liable, to be negligent, but at the same time, the liability of the hotel was reduced by 20% because the court found that the uh, plaintiff's own negligence contributed to the harm. In Coles Supermarkets, Australia Proprietary Limited versus Bridge, a customer fell on a wet patch in an underground car park while he was using his phone. So while indeed there was negligence on the part of Coles Supermarket because it should have taken care to ensure that the wet patch, for example, in its underground car park would have been removed because it was dangerous, it posed a hazard to customers and other people. Yes, that's true, it was negligent, but at the same time, it would have been possible for the plaintiff to avoid harm to himself if he had paid attention and not been using the phone. But it was actually as a result of his own negligent actions in not paying attention, using his phone so that he was not completely aware of his surroundings, including being able to observe the wet patch. So there was therefore contributory negligence on the part of the plaintiff claimant. And for that reason, there was a 25% reduction in the damages awarded to the claimant. Now, this is an interesting case, which I mentioned earlier, Consolidated Broken Hill Limited versus Edwards. So in this particular case, what the cyclist, okay, that particular picture actually is a picture that I took, okay? So don't judge or don't judge me, don't judge the plaintiff. I'll talk about the case in a short while, but before I talk about the case of Consolidated Broken Hill versus Edwards, if you look at the picture, that's a picture I took. It doesn't, when you look at it, it's actually elevated. They've actually got trees on the right. And you will notice that those trees are actually of the same height as the railroad tracks, okay? So this was in Stanford. This was one of those times last year when, on hindsight, I felt what I did was actually very negligent. So my wife and I went to Stanford. It's in the southern Downs region of Queensland to look at the sites. And we came across this railway track, which appeared to be abandoned. In terms of the length, it was probably about 150 meters. And so, I don't know what I was thinking, but imagine me walking from where it was safe all the way to the middle of that railroad track. The problem is, if you will notice, there are no guardrails on the sides, there are no walls. If I slip and fall, that's a distance of about 6 meters. That's serious injury. The reason I did that was because I saw somebody who was younger, probably in his 20s, who just casually walked along those tracks and taking photos. And I said, why not? It must look nice to do that, which is what I did. But when I was in the middle and was hoping to actually cross just to prove, just as a form of bravado, I realized, my goodness, this is extremely dangerous. I could fall off. And so therefore I slowly went back. Okay. So that was stupid. Anyway, and I thought about that when I was thinking about the case of Consolidated Broken Hill Limited versus Edwards, because in this particular case, the cyclist fell into a creek and became a paraplegic after a jumper. He was wearing a jumper, as a biker. He was wearing caught on a protrusion from a rail wagon on the defendant's land. So there was a railway, an elevated one. He had tried to cycle across a narrow space, which is 40 centimeters. That's just, that's not a lot, right? But he was an accomplished and experienced cyclist. He felt comfortable he could do that. And there were no walls or barriers on each side, just like what I did when I walked along those railroad tracks in Stanford. So there were no barriers. And because his jumper caught on a protrusion from a rail wagon, because there were rail wagons that were parked in the railroad area, he fell on the creek below and he became a paraplegic. Imagine that. So what would have been an enjoyable ride, just ended up in a major tragedy. Can you imagine that? You're enjoying a good day, enjoying cycling, something that you've always wanted to do. And, by a single mistake in judgment, you become paraplegic. It happens a lot, right? So in this particular case, it was clear that the defendant was also negligent because it could have taken steps to avoid anyone from using, that part of the railroad tracks. So it was negligent, but the defendant was saying that the plaintiff himself contributed to the harm by his own negligence. So in that particular case, the court found that the plaintiff was in fact negligent, and they increased it to 50% because initially the lower court only felt that the harm or injury to the plaintiff was only partly a result of his own negligence, so pegged it at about 20%, but that was increased to 50% by the Court of Appeal of New South Wales. And in that particular case, the Court of Appeal said individuals should care for themselves as much as they expect others to care for them. People should take responsibility for their own lives and safety. So it's like, you go biking or you might even just be walking on a shared footpath where, you have pedestrians and bikers. And a pedestrian can just say, oh, it's going to be the responsibility of the bikers. So if the pedestrian himself or herself were not careful, and as a result, got hit by a bike, leading to serious injuries for himself as a pedestrian, but there was negligence also on the part of the pedestrian by not looking around or not being aware of the surroundings, that there could be contributory negligence, which would mean a reduction in the amount of damages that could be recovered by a particular plaintiff. Okay, think about that. Now, one of the questions we then said was that when we talk about objective standards and we pitch it at the level of an hypothetical reasonable person, what then do we do when we're dealing with children? So in the case of Kelly versus Vega Valley County Council, we had an 11-year-old plaintiff, a child, who was injured by electrocution after touching a high voltage light pole terminal. Do we measure contributory negligence on the basis of the hypothetical reasonable person of mature age, or do we pitch it lower to that of a child who's 11 years old? Would that then change the principle about there being an objective standard? The court said that the objective standard in that particular case, dealing with an 11-year-old child, should be adjusted in terms of what the hypothetical conduct of an infant of the same age should be. So there is a modification of the objective standard. It is still an objective standard because it doesn't look at the peculiarities or subjective characteristics of an 11-year-old as an individual. It speaks of what would you expect of children, of most children who are 11 years old, when it comes to touching a high voltage light pole terminal. So it's still an objective standard, but pitched at a lower level, at the level of the hypothetical conduct of an infant of the same age. In Doubleday versus Kelly, the court said that the relevance of the 7-year-old child was considered in the obvious risk context, so that the child's age was relevant to an assessment of reasonableness in the circumstances. Again, when we talk about the child's age, it's not so much looking at the subjective characteristics of that 7-year-old plaintiff, but looking at what you would expect of the hypothetical conduct of children of 7 who are 7 years of age. So we've talked about a modification of standard in relation to children. The question is, should there also be a modification of the objective standard in relation to intellectually disabled persons and persons with physical disability? In this particular case of Russell versus Air Infrastructure Corporation, there was a 21-year-old woman with mild intellectual disability climbed onto the side of a slow-moving goods train. She had been with her friends, and who were quite good in climbing over a fence and then climbing onto the side of a slow-moving goods train. So this particular plaintiff was trying to show, I can do this myself. But in the process, she became scared when the slow-moving goods train suddenly began to pick up speed. She let go and she injured herself seriously. The question is, should the standard of the objective standard of a hypothetical person be adjusted in relation to people with intellectual disability, and what is the significance of that if you do in relation to the notions of objective standard of care. And the court said that an issue is whether the plaintiff failed to take reasonable care for her own safety that is expected of a reasonable adult having a mild degree of intellectual handicap. So in other words, in this particular case, the court did take into account the issue of intellectual handicap of the plaintiff. So, but in that particular case, that still isn't a subjective standard. It's not about changing the standard to look at the peculiar characteristics of the mild intellectual plaintiff, but looking at it more broadly in terms of what would you expect of reasonable adults having a mild degree of intellectual disability? How would they react or act in these circumstances? And in this particular case, the court felt that the plaintiff failed to take reasonable care for her own safety, but had a lesser capacity to reason and to exercise judgment because of her intellectual disability. Even so, she would have appreciated that in jumping onto a slow-moving goods train, she was exposing herself to a serious risk of injury. And so therefore, the defendant's conduct, but at the same time, the defendant's conduct was also a significant departure from the standard of care that it holds. So the Rail Infrastructure Corporation was also a significant departure from the standard of care that it owed to the plaintiff. So here, the plaintiff's damages was reduced by 50%. Now, let's look at employment contexts, and then later on, we'll look at issues about intoxication. In McLean versus Stedman, we had talked about this in the previous weeks. This was a situation where you had a garbage collector who moved around, from street to street, crossing the street to pick up the garbage bins. That would be quicker, right? Like, at least in our neighborhood, if there is a garbage truck trying to collect bins, and of course it's now kind of more automated. You don't really have individuals running around, but perhaps in other areas there are in fact human garbage collectors who come down and grab the bin and so on. Oh, that's still true for the green bins, where there are actually individuals who come down and grab the green bin. So anyway, in this situation, it was more efficient for the garbage collector to cross the street. So that became the practice. And then that individual was hit by a car. The question then is whether that failure by the garbage collector should be characterized as mere inattention or inadvertence, or whether it amounts to negligence. It is accepted that in considering whether there was contributory negligence by an employee in a case in which the employer has failed to provide a safe system of work, the circumstances and conditions in which he had to do his work must be taken into account. So in other words, if an employee suffered injury in an employment setting, and there was no safe system of work provided by the employer, even if there might have been what might be considered to have been negligence on the part of the plaintiff employee, it wouldn't amount to the level of negligence under tort law, but it would simply be characterized as mere inattention or inadvertence. Because in that case, the greater reason why the plaintiff employee suffered harm would have been the failure on the part of the employer to provide a safe system of work. So here, the court held that there was no contributory negligence. So the court here highlighted the distinction between mere inattention or inadvertence and contributory negligence. In other words, not every failure to be careful is regarded as negligent under tort law. And this is important because what we should often notice is that the employee's conduct can take place in a situation of risk that is created by the employer's own negligence. So here, because the employer failed to provide a safe system of work, then what might have been considered to be negligent action or omission on the part of the employee was not considered to be negligence under tort law, but mere inattention or inadvertence. Now, which raises the question, what also happens when there is a safe system of work that has been designed and implemented by the employer, but somehow the employee fails to observe the safe system of work. And by failing to observe that safe system of work, the employee becomes injured. Would there be contributory negligence on the part of the employee? That's something we're considering in a short while. Think about that question. So in the case of Commissioner of Railways versus Ruprecht, this involved a plaintiff, the shunting operations workman. So shunting, I think it's about changing where the train moves, right? The goods train moves. So by shunting it can go here, it can go there, can go there, whatever. And here, in this particular case, the shunting operations workman, without looking, stepped onto a railway line in front of a moving wagon. But it was actually a different person who was controlling at that time the shunting operation, but he was not really paying attention. The question was he, liable because he wasn't looking? He just stepped onto a railway line, and the injuries, as you can imagine, would be horrific if you happen to come in front of a moving rail wagon, right? So here the court said that inattention born of familiarity is one of the factors to be considered concerning contributory negligence. Lapse of attention, which is not incompatible with the conduct of a prudent and reasonable man. The plaintiff's inadvertence was not such as to amount to a failure to take reasonable care for his own safety. So as human beings, we are prone to have a lapse of attention. That is not an issue. The issue is if the employer failed to factor in the possibility, well, not the possibility, factor in the fact that people can be inattentive at times. So in other words, there is a duty on the part of the employer to make sure that any safe place work design that it creates takes into account lapses of attention by its employees. So in other words, not every failure to be careful is considered negligent. So here the court said that the plaintiff's inadvertence was not such as to amount to a failure to take reasonable care for his own safety. The employment demanded and obtained the plaintiff's concentration upon it and involved a risk of danger to which the plaintiff had become habituated. So this was something that was constantly happening because of the urgency of the work and other tasks that the plaintiff had to do. It was reasonably foreseeable that there would be moments of inattention. And so here, the full burden of the damage was placed upon the defendant commissioner of railways. Now, it can also happen that an employee might not be contributory negligent, even if he or she exposes himself to the risk of injury. And this is a situation almost similar to the case of Commissioner for Railways versus Holly, where you have a trainee shunter whose own conduct was dangerous, lost both legs after being run over by a railway wagon during shunting operations. So here, the defendant was negligent. It failed to give proper training and instructions. So that the plaintiff knowingly did something that he knew to be dangerous. But that fact alone does not show a lack of reasonable care for his own safety. So the court said that a finding that the plaintiff knew or ought to have known that what he was doing was dangerous does not necessarily establish that he knew that he was guilty. Doesn't establish that he was guilty of a lack of reasonable care for his own safety in the circumstances of his employment. It would have to be established that even though it was highly dangerous, it was not required of him in the performance of duty. So in other words, if it is the employer itself which is causing the employee to perform certain dangerous tasks, it is no excuse for the employee, it is no excuse or no justification for the employer to then say that the employee was aware of how dangerous it was. In the first place, the employer must do something to ensure that the employee does not have to be exposed or subjective to a dangerous situation. In Zatirko versus Edith Cowan University, this involved an employee loading a truck. And as the employee was loading a truck, he stepped backwards and fell. The employer, however, was liable for not having devised a safe system of work. So a safe system of work would have been, ways of putting in signaling devices or safety mechanisms and so on, so that in that particular case, a safe system would take into account the possibility that at some point one of his employees may be forgetful and be inattentive, or maybe inadvertent in the way that the task was being done. So in this particular case, the court said that the appellant's attempt to step onto the platform in the mistaken belief that it was still raised, and in an effort to finish loading the truck, was the product of nothing more than mere inadvertence, inattention, or misjudgment. His actions were neither deliberate, intentional, nor in disregard of a direction or order from the respondent. And notably here, the plaintiff was under pressure from the supervisor to complete the job promptly. The work was repetitive, habitual, and in all these circumstances, it presented a fertile field for inadvertence. So again, here, the employer was fully liable for the damage suffered by the plaintiff. Now, let's look at the issue of intoxication. Would intoxication factor in relation to contributory negligence? There are two parts to it. The first part is what is the effect upon the plaintiff's claim if at the time that he or she suffered harm, he or she was intoxicated. So that's question one. Related to that question is, do you take into account the fact that a plaintiff may have been intoxicated, and that intoxication impaired the ability of the plaintiff to think properly about his or her own actions? In other words, it diminished the ability of a plaintiff to act. Now, we recall that in the previous cases we looked at, if a child, if a claimant was a young child, or if a claimant had mild intellectual disability, or strong, heavily, or severe intellectual disability, the court did take these into account in saying that when you look at the standard of reasonable care that you would expect of a plaintiff, you would have to adjust it based on objective standard of what people in this kind of cohort or this kind of population, how they would behave. So what is the significance of a claimant being intoxicated? So that would be a significant factor when determining liabilities. So for example, in the case of McKenzie versus nominal defendant, the contributory negligence was reduced from 100%. So a just and equitable reduction is 80% because the appellant or plaintiff put Mr. Brown in the driver's seat knowing that he was unlicensed, inexperienced, and intoxicated. In Jocelyn versus Merriman, where we said that both of them were aware that they were both drunk, the High Court said that the issue is not whether a reasonable person in the intoxicated passenger's condition, if there could be such a person, is there such a person, of a reasonable person in the intoxicated passenger's condition? That was the thinking of the court. So the issue is not whether a reasonable person in the intoxicated passenger's condition would realize the risk of injury in accepting the lift. It is whether an ordinary reasonable person, a sober person, would have foreseen that accepting a lift from the intoxicated driver was exposing him or her to a risk of injury by reason of the driver's intoxication. So that a reasonable person in Mr. Berryman's position would have been aware that she was probably still affected by alcohol when he became a passenger in the vehicle. So there was contributory negligence by Mr. B. So here, the standard of care would be the standard of care expected of a sober person, not that of an intoxicated passenger or an intoxicated person. So a plaintiff who is intoxicated cannot claim that, you know, my ability to take care of myself is diminished by my intoxication. That is not a proper way of articulating a defense, because the standard of care, the measurement would still be that of a sober person. In Avram versus Gusakowski, though, it was kind of different, because here both passengers and both the passenger and the belligerent driver were intoxicated. But in this particular case, there was no contributory negligence that was seen on the part of the intoxicated passenger, who, like the case earlier of Justin versus Berryman, rode in a vehicle driven by a driver who the plaintiff knew was actually drunk. Now, the reason for this was that in the circumstances, it could not be said that the respondent agreed to accept the services of the inebriated appellant as driver. The appellant services were forced on him. The reason for this was that the plaintiff actually tried to ask the driver who was intoxicated to stop, because the plaintiff felt that the driver was driving dangerously, especially as a result of the intoxication. So here, there was no reasonable time in which he could decide whether or not to drive with a drunk driver, because the driver just drove off. So there was some latitude in assessing the injured person's conduct in the agony of the moment. His conduct was not unreasonable conduct in the circumstances. Now, the Civil Liability Act has also intervened in relation to the common law. So that's in section 47. Subsection 1 says that this section applies if a person who suffered harm was intoxicated at the time of breach of duty, giving rise to a claim for damages and contributory negligence is alleged by the defendant. So number 2, contributory negligence will, subject to this section, be presumed. So if there is intoxication on the part of a claimant, then the law presumes that there was contributory negligence on the part of a claimant. But at the same time, under subsection 3 of section 47, it also provides that the person may only rebut the presumption by establishing on the balance of probabilities, A, that the intoxication did not contribute to the breach of duty, or that the intoxication was not self-induced. So in other words, just because a claimant was intoxicated at the time of the breach of duty doesn't mean that there then must be contributory negligence on the part of the claimant, because if it could be shown that the intoxication did not contribute to the breach of duty, or that the intoxication was not self-induced, then there is no scope to say that there was no contributory, that there was contributory negligence. So you can have a situation where you have a very sober driver who is not intoxicated, obviously, and you have a passenger who is drunk. Now, if that sober driver, acts negligently and causes an accident which leads to injury to the drunk plaintiff, why would there be contributory negligence on the part of the plaintiff simply because he or she may have been drunk? So in that case, it could be clearly shown that the intoxication on the part of the plaintiff did not contribute to the breach of duty. Now, as we said, we talk under the legislative developments of the state parliaments. There's now an apportionment of liability. In Pennington versus Norris, the High Court said that in terms of apportionment, what has to be done is to arrive at a just and equitable apportionment as between the plaintiff and the defendant of the responsibility for the damage. It seems clear that this must of necessity involve a comparison of culpability. By culpability, we do not mean moral blameworthiness, but degree of departure from the standard of care of the reasonable man. Under the Law Reform Act of 1995, Queensland, Section 10, subsection 1, the damages recoverable in respect of the wrong must be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. Again, we also note that under Section 24 of the Civil Liability Act 2003 Queensland, it provides that in deciding the extent of a reduction in damages by reason of contributory negligence, a court may decide a reduction of 100% if the court considers it just and equitable to do so, with the result that the claim of damages is in fact defeated. So as a review, in order to prove an action for the tort of negligence, so this is now the part of the plaintiff, it must be proven that the defendant owed a duty of care to prevent harm of the kind suffered by the plaintiff. 2, that the duty of care had been breached. 3, it must be proven that it was in fact the breach of duty that was the cause of the damage caused. And 4, finally, that there is no defense, whether the defense is based on contributory negligence, voluntary assumption of risk, illegality, immunity from civil liability, and exclusion of liability cases. Again, as a reminder, as far as defense is concerned, we're only looking at the topic of contributory negligence, and we don't include in our unit the other defenses, and these other defenses are not going to be assessed in our unit. So at the end of this module, students should be able to understand the scope and definition of the defense of contributory negligence at both common law and statute, outline the central factors taken into consideration by the courts in dealing with the defense of contributory negligence, and apply and identify and apply appropriate defenses in particular fact scenarios. So with that, I end this particular recording, and I hope you found it informative and I was about to say enjoyable to watch. Just say informative. So I'll see you soon. Thank you. Thanks for listening and watching. Bye.